Welcome, everyone. We're going to be giving folks another minute or two to just trickle in, and then we'll go ahead and get started. All right, so let's go ahead and jump right in. Hello, everyone, and welcome. I'm so glad you could join us today for No Show, No More, Rethinking Court Appearance and Reminders. My name is Bridget Rivera-Degnan, and I'm a Senior Policy Manager with the Data Collaborative for Justice at John Jay College, and we're thrilled to be co-hosting this webinar with our partners at Ideas 42. We know your time is valuable, and we're really excited to spend the next 75 minutes with you digging into one of the most practical yet transformational areas of pretrial justice, how we can help more people make it to court. So here's a quick look at where we're headed today. We'll start with a short welcome, that's me right now, and then we'll get into the problem, understanding why people miss court dates in the first place. From there, we'll move into the solution, how courts around the country are using reminder systems and behavioral science to support court appearance. Then we'll talk about why it matters, looking at the broader impacts on fairness, efficiency, and trust. And finally, we'll wrap up with a panel discussion and audience Q&A, where you'll hear directly from practitioners who've implemented these approaches on the ground. So by the end, we hope you'll walk away with some concrete ideas, whether you're building a new reminder program or improving one that already exists. We've got a really terrific group leading today's conversation. First, you'll hear from Shannon McAuliffe, Associate Managing Director with the Unwarranted Initiative at Ideas 42. She'll be setting the stage and walking us through the behavioral science behind this work. Next is Renee Ropak, Senior Research Associate with the Data Collaborative for Justice. He'll be sharing new research on court appearance patterns and what the data actually tells us about why people miss court. And then I'll be joining in to discuss the broader importance of reminder systems and to moderate our panel discussion at the end. We're also joined by an amazing group of practitioners who are putting these ideas into action every day. You'll hear from Martha Wright with the Judicial Council of California, Jeffrey Balbuena from the New York City Criminal Justice Agency, Chris Phelps, Court Administrator in Scottsdale, Arizona, and Eric Jackson, an independent researcher working with Code for Asheville in North Carolina. Each of them brings a unique perspective on what it actually looks like to design and run reminder programs in real-world court level settings, and we're really excited to learn from each of them. Before I hand things over to Shannon, I'd like to just give a quick look at who we are at the Data Collaborative for Justice, or DCJ. DCJ is an independent research center based at John Jay College of Criminal Justice. Our team brings together researchers, data scientists, and policy folks who all share one goal: advancing fairness and transparency in the criminal legal system. We're nonpartisan and data-driven, which means we don't start with a position, we start with the evidence. We work closely with government agencies, advocates, and communities to understand what's really happening in the system and how we can make it better. And what we do is we take that data and we turn it into action. We analyze how policies and practices actually play out in people's lives, and we produce research that's not just interesting, but useful, things that decision makers can act on. So that's a bit about who we are and what we do at DCJ. And with that, I will hand it over to Shannon.
Thank you so much, Bridget. Appreciate it. So I am Shannon from the Unwarranted team at Ideas 42. We're a nonprofit behavioral science firm. And what we do is really help courts improve their court date communications. So things like court reminders, court date forms. But we also, most importantly, we partner with courts to create effective communication programs. So you can have a reminder system, but if it doesn't reach anyone, that's not particularly helpful. You can give somebody a form, but if the most important salient information isn't landing and memorable, again, not optimal. And we also help courts choose the best technology that they can for a reminder program. Our goal is to reduce non-appearance by up to 36%, and we have done that and proven that in other projects. So we're going to lead you through that. Now, let's talk about the problem of missed court from a behavioral science perspective. So this is the traditional model of behavior and how we believe people act. They have an intention, they act on it, right? But not so fast. Behavioral science shows us how people really act. So you might not have an intention to go to court because you might not know you have court, or you might be too afraid to go. But let's say you even have the intention. You might forget, it might be unclear what you're supposed to do. You might not have transportation. Your current needs that day might be more important than this court date that you're now weighing against. Or maybe you want to ask questions, but you don't have anybody to call. So all of these things can result in people not going to court despite their best intentions. So we know the basic barriers, usual suspects on the right-hand side. And then we have the behavioral barriers, and that's what we're going to be talking about and what improving court communications can really address. So one, people have limited bandwidth. If you're experiencing poverty, it's likely that a court date can just fall out of your purview. And this is scientifically proven. Things can be hassle-filled, and we want to really remove those hassles. So we help courts on their processes also. How do we make it as easy as possible for people to get to court? And of course, fear and distrust and forgetting, again, all of our communications can help address those barriers. So when you think behaviorally, it really begins to uncover a different way of handling non-appearance and getting people to court. So status quo is if people really think court's important, they'll find a way to get there. But we've done studies where we've talked to people. Every single person has told us they've tried to get to court, but despite really their best and impressive efforts, sometimes they just don't make it. Status quo, people like lose track and so they just aren't paying attention. But in reality, the information might be at fault. You're all dealing with a high volume, people make mistakes. I've sat with people outside of a courtroom and looked at their forms, and there could be 2 court dates, a wrong court date, no court date. So mistakes happen. And then, of course, the old status quo, if we make penalties harsher, people will come. But we know that's not true because we're in the, like, we have the problem we have with non-appearance. But really, when people are afraid, they might stay away. So again, how do we devise our communications and processes to address this? So the problem is widespread. There are tens of millions of low-level charges each year. Misdemeanor courts alone have 3.5 million. On average, about a third of these court dates are missed, more the lower the case level is. Some courts have 60% non-appearance rate. And the cost doesn't match the crime. So you have this low-level charge, and then you don't appear and you have a warrant. So it's very costly to people. But it also costs money. So we know that a missed court date costs the government about $1,500, again, in court staff, attorneys, warrants, jail. It also costs the person about $1,350 if they have a warrant and it results, if the missed appearance results in a warrant. So again, it is costly. So the 2 main takeaways here are that we have a problem and it's costly. And now I'll turn it over to Renee to tell you about a project they did in New York about who's missing and why. Renee?
Good afternoon, everyone. My name is René Ropak. I'm a senior research associate at the Data Collaborative for Justice. Today, I'll talk about our research findings regarding failure to appear, or FTA, across New York regions. Before I get into our actual findings, I want to quickly talk about the data and the sample that we used. So the data that we used comes from the Office of Court Administration, OCA, and the Division of Criminal Justice Services, DCJS. And we analyzed cases that were released at arraignment across New York State in 2022 in order to identify patterns and predictors of failure to appear in court. And when I say released at arraignment, I mean people who were released either on their own recognizance, that is without any release conditions, or on non-monetary release conditions, primarily pretrial supervision. The way that we defined FTA, or failure to appear in court, is any non-state warrant that has been issued between arraignment and disposition. That is a warrant that was immediately executed. So, for example, an FTA is counted if someone has 10 court appearances for the court case but misses just one appearance. And the research questions I'm addressing today are twofold. The first step looks at how FTA rates differ by region, the current charge, criminal history, and demographics. To do so, we computed the raw FTA rates for those different subgroups. And then the second step, we also control for other characteristics in order to see what factors predict higher or lower FTA rates, all things equal. Therefore, we estimated FTA rates by statistically isolating each other factor from all others. So, for example, people with prior misdemeanors are also more likely to have prior felonies as well. And so the second step better isolates the real association or effect of each type of prior. This slide is the first one that shows the raw FTA rates statewide as well as for the different regions in New York. So for context, in 2022, New York judges released the vast majority of people on ROR or non-monetary release conditions. That is 84% of individuals were released without money bail. What's noteworthy here is that most New Yorkers don't miss any of the court dates in all regions. There's very little variation across regions, so appearance rates are between 80% in the upstate regions and 84% in New York City. And across all regions combined, we have an 83% perfect appearance rate. Just a quick note, when I say New York City suburbs, I mean Long Island, Westchester, and Rockland County. Next, let's look at the charge severity. One very noteworthy finding is that violent felonies have an especially low FTA rate of only 13% statewide. That's compared to 20% statewide for non-violent felonies and 16% for misdemeanors. And again, there's relatively little regional variation. When we look at the different types of instant charges, we see that the specific charge matters a great deal. We see a lot of variation between the charges associated with the highest FTA rates, that is specifically petty larceny, misdemeanor drug possession, and burglary, and the lowest FTA rates charges, which is DWI, or driving with influence, which have the lowest FTA rates across the board. Again, the variation across the three different regions is relatively minor. When we look at it by prior criminal history, a very strong predictor for FTA is having a pending case at the time of arraignment, and that's most likely because having a pending case signals recent justice involvement. So statewide, almost 1/3 of people released. Of people who were released and who had a pending case at the time of their arraignment also failed to appear in court, compared to only 11% of people with no pending case. So the risk of FTA really is threefold for people with a pending case compared to those without a pending case. Likewise, what's not shown here, and I go into that later in more detail, the FTA risk also increases with the number of prior misdemeanor convictions. So people with 0 prior misdemeanor convictions have a 12% FTA rate, compared to people with 5 or more prior misdemeanor convictions who have a 35% FTA rate. Now, let's look at the risk factors after isolating each other factor statistically. Spoiler alert, the overall results did not dramatically change. We still have the same primary risk factor even once other factors are controlled for. So by region, even after adjusting for a number of case characteristics, we still found minimal differences in FTA rates across regions, which are still at 20% or below. When we look at charge severity, FTA rates for VFO are still the lowest. People charged with violent felonies had FTA rates of only 13% when released, compared to misdemeanors. That's a 10 percentage point gap, where we had the 23% FTA rates. So another question we asked, since obviously those are the rates for people who were released, what would have happened if people who were actually held on bail were also released. So to address this, we used a mix of charge and criminal history characteristics and extrapolated the FTA rates to those types of cases that were actually held on bail or remanded. And what we found here is that people charged with a violent felony who did face bail or remand had a projected FTA rate of 16%, which really is only 3 percentage points higher than the observed rate in the actually released cases. And that suggests that judges are actually not ordering people with substantially higher FTA risk to bail and detention. And by the way, we focused on VFOs here, on violent felonies, because they're still almost universally exposed to bail and detention under New York law. So bail was banned for most misdemeanors and nonviolent felony cases. And finally, the charge type still matters even after controlling for other factors, with the highest rates for petty larceny, burglary, and misdemeanor drug possession between 25 and 28% FTA rates, and with the lowest FTA rates for driving under influence and felony weapons cases. Again, the largest criminal history, the strongest criminal history predictors for FTA are still having a pending case. Here, the likelihood varies between 13% for those without a pending case and 23% for those with a pending case. And then prior misdemeanor convictions are still an independent, strong predictor, where we have a 15% FTA rate for people with 0 priors and a 23% FTA rate for people with 5 or more priors. Surprisingly, perhaps what has a minimal effect or actually no effect on FTA risk is prior felony convictions. So once we account for pending case status and prior misdemeanor convictions, having a prior felony really only changes the FTA rates by up to 2 percentage points. So not that much. Likewise, people who are currently on probation or parole also have very similar FTA rates to those who are not currently on probation or parole. And then finally, and importantly, when we look at association between FTA and race and ethnicity, we actually find very little association. So all groups across all types of charges have an FTA rate of exactly 17%. When we only focus on VFOs, again, those are the types of charges that are still eligible for bail in New York. We also see very little variation where Black individuals have an FTA rate of 13%, comparing to 14% FTA rates among Hispanic individuals and white individuals. And that's just for context. Multiple studies have found that New York courts set bail more often for Black and Hispanic people. And in the current study, we also found a 10 percentage point Black-white difference, which doesn't seem to be warranted given the FTA rates across those populations. And then just to wrap it up, the conclusions from our study are, one, New York judges could release more people under the current law without increasing failure to appear rates. And that's especially true for violent felony cases. Second, criminal history matters, but some factors matter more than others, where the biggest risk factors are having a pending case and having multiple prior misdemeanor convictions and having a prior felony conviction or a probation or parole status make a very little difference in terms of FTA risk. And finally, judges are setting bail disproportionately for Black and Hispanic people despite similar levels of FTA risk. And then finally, a couple of limitations just to keep in mind. In our study, we were not able to distinguish between warrants that were issued for a missed appearance versus other factors. That being said, the vast majority of warrants are issued for failure to appear in court. We also lacked measures that have previously been shown to predict failure to appear in court. That is a history of failure to appear in prior cases and certain community ties factors, such as having a job or a constant address. And finally, we cannot account for the recency of past convictions. So we can't differentiate between a conviction that is 10 years old and one that is 1 year old. So that's just another limitation to keep in mind when we look at those numbers. And thank you very much. I'll give it back to the rest of the panel.
Thank you so much, Renee. So you might be wondering, why does New York have a lower FTA rate? Well, they send reminders by statute. So This is just to show you a project that we did in New York City, which sort of began all of our work on this back in 2015. We redesigned the summons to include a phone number field and use that phone number to send reminders. There was a 26% decrease in non-appearance among those who provided a phone number. Also, it was doubly as impactful for people in communities with the least wealth. So again, incredible results and shows that a sort of low lift can have a very high reward. So let's dive into building an effective reminder system. So one of the most important foundations is enrollment, and I'll explain why. We strongly suggest that you automatically enroll everybody for whom you have a phone number or an email into reminders, and they can opt out. Now, a lot of courts say, well, we'll just have people sign up. But behaviorally, it doesn't work because it requires people to take a lot of steps. One, they have to know that they need a reminder, know that there's a reminder system. Two, they have to have the intention to sign up. And most people don't know how important it is, which is why your dentists and doctors and restaurants email or text you, even though you don't ask them to. And then they have to actually sign up. And it's simply just not going to happen at each step, and you're going to lose people. We can take a page out of Colorado's book. So they had people sign up. And then as you can see, in September of 2022, they passed a law that required that everybody be automatically enrolled into reminders. And there was a dramatic jump. So usage went from 1% to 95%. And they saw a 34% decrease in FTAs. So it was a total game changer. Now, you have to let people opt out, but what we see is that opt-out rates are very low, usually 3%, 2%, and they're often related to a wrong number. And this is what behavioral science is all about. It's about changing your process to work with how people actually act, not how we expect them to act. And again, here, automatically enroll people, get them the reminders they need because we know that they help. Now, some courts still require people to sign up because there's a misconception that a federal law called the Telephone Consumer Protection Act somehow bars auto-enrollment. But actually, when you dig into the law, it bars automatic dialing systems, those random number generators. And with court texts, you're not randomly generating numbers. You're sending reminders to people whose number you know belongs to them. Even if somehow we think that applies, which it doesn't, the TCPA also says that you can contact people if you have express consent. And the case law shows that express consent is satisfied if somebody gives you a number in a related context, like at booking or to a law enforcement agency. So again, under the current law, we do not believe that the TCPA bars auto-enrollment. Now, you want to collect contact information as early as possible. And this is something your court's just going to have to think through and work with your law enforcement partners. You want the jail to be asking for a cell phone number at booking, or your law enforcement agency to be asking for it when they're citing and releasing somebody. Why? You need that reminder to hit the person's phone or email before that first out of custody hearing. If you wait until people come to court, you miss everybody who doesn't come to court. Now, at court, of course, you want to ask people for their phone number, verify that what you have is correct. But the most important thing is to get that reminder to people before that first out of custody hearing. It's the most missed hearing, and it's important to start people out on the right foot so that they continue along. Now, this is something we did in California. We revised their citation to add a phone number field. We also made some other tweaks. Behaviorally, we changed the title to show that not everybody needs to appear. We used the space in ways that are proven to increase appearance. So we put the date at the top and in bold and the consequences there and told people where they need to go. But most importantly, what we did is we added a place where they can capture the phone number or email. And I'm going to hand it over to Martha to tell you from the Judicial Council of California to tell you about our project with her. Martha?
Yeah, thanks for having me, and thanks everybody for joining. This project that we did with Ideas 42 was a big one, and we wouldn't have been able to do it without some outside assistance and some expertise lent to the work group that came together to consider all the options. In California, we knew that the citation was really old. It had been 10 plus years since it had been looked at. And as Shannon went through, there really were a lot of things on it that were not designed for the defendant as the recipient of that ticket. A lot of things that were really designed more in mind with case processing and data flow. But we know that the case processing and the data flow can still happen, and we can make the form itself easier for people to use also. It's the thing that people are given and walk away with, and it's the thing that they first get to know what they're supposed to do next. So as Shannon mentioned, really one of the bigger ticket items was to move information to the top that made it easier to understand what to do next for the person receiving the citation. And then at the bottom, when somebody signs the citation, we altered the field a little bit to make a little bit of room to collect phone number. And we indicated here, had lots of discussion about the best way to say it, but ultimately the Judicial Council finally approved a version where we're indicating may be used for reminders. And an email as well. You'll see that email is in yellow. There are some yellow fields on the citation in California where local law enforcement agencies can choose to use them or not. They're editable fields in essence. Most law enforcement agencies, I think, have left that there. Email can be a little clumsier to collect than cell phone number. So cell phone number really is sort of first and foremost, and right there when somebody signs. So citation volume is high. It's really high, mostly with traffic tickets, a classic traffic ticket, but also for misdemeanors. Some people are given a citation, cited and released for a misdemeanor in the field, and that's what they have to walk away with to know what they do what they need to do next. So it was really important to try and make it more user-friendly.
Thank you, Martha. So we are in the process of evaluating this. If anyone needs a phone number field added to your citation, you can call us and we can help. But it was a really fun, exciting project to do with California. Okay, so let's talk about the key elements and really the infrastructure that works for a reminder program. So we talked about collecting contact information, and again, California is doing it on the citation, which is amazing and optimal. But you can send a reminder with a text, an email, mail, or calls. Here you can see the pros and cons. Typically, text has the most pros, the least cons. Emails change less, but again, as Martha said, clunkier to collect. It could get lost in the junk. Now, a lot of times people think that they sort of disregard mail, but don't disregard it because it still works. We did a project in Sacramento where they sent a mailed reminder before arraignment, and there was an 8.2% decrease in non-appearance. So it was so popular that they've actually expanded it to sending mailed reminders for all court cases. Calls are harder again, but these are the various delivery methods. Now, who sends the reminders, right? Now, there's two different ways. The state AOC can send the reminder if you have a universal CMS with all of your states, like for example, North Carolina has that. But there are lots of states where each county has a different CMS, like California, like Texas, like a lot of different states. And when that happens, you can take a page out of Texas's book. So Texas said, we need to send reminders. We don't have a universal case management system. So they hired a vendor, eCourtDate, that works with any county court that wants to provide them reminders, and the AOC pays for it. So that is expanding this year and working really well. The alternative is that an individual court or county can do it on their own. Some nonprofits do it. You'll hear from Eric from Code for Asheville, who really spearheaded this in Buncombe County on his own. And pretrial agencies and defenders also do this. Now, technology. There are really three different buckets of what you use, and these are for text reminders. So turnkey, this means that your case management system has something you can turn on and it turns on reminders. The drawback is that the content is not flexible. They usually say, this is our content, you can't change it. Do it yourself. Your court IT department builds their own from scratch. Nonprofits can also do this, and a specialty communications platform. This is a vendor like we were talking about eCourtDate. There's many other ones too. It's sort of a white glove service, and they work with your non-technical staff in getting reminders up and running. Now, turnkey is a low lift for courts. Do it yourself, somewhat higher because you're creating your own system, and the specialty platform, communications platform, you work with them in devising the reminder program, but then they have dashboards and other things that are really helpful for the court. Costs depend on your current IT capacity, but all have a staggering return on investment. Reminders cost court $1 or much less over the years to avoid a $2,850 cost in a missed court date, which is about $1,500 for the system. If you have a volume of about 10,000 cases a year, it might cost you between $8,000 and $16,000 for reminders, but you're going to avoid $1.7 million of system costs just by sending reminders. So again, low lift, high reward. Oh, and now I'm going to turn it over to Jeffrey Balbuena to talk about what they did in New York. Jeffrey?
Hello, thank you. So first of all, hello everyone. Thank you for joining. My name is Jeffrey Balbuena. I am the Senior Manager of Outreach Services at the New York City Criminal Justice Agency. So I'm going to speak a little bit about CJA's core reminder infrastructure, or as I like to call it, like how we turn court data into timely reminders that help people get back to court. So CJA has a comprehensive reminder system in New York City. We work closely with the Office of Court Administration, OCA, to send reminders to the court parts that they direct us to. So we handle most court appearances in criminal and Supreme Courts, as well as desk appearance tickets and fine payments. So to understand our core reminder infrastructure, it helps to think about it in 3 steps: input, process, and output. So when we talk about input, we're talking about what comes in, the data. So we have different sources. One of the unique things about CJA is that we conduct our own release assessment citywide. So we are gathering data in all booking locations. So that's one of the sources that we utilize to gather contact information. We also receive information from the Office of Court Administration. So we receive 2 feeds. One is the core data feed and the next schedule feed. So our IT department manages like secure data transfer, and all this information is stored in Data Hub, which Data Hub is our internal platform that supports operational and research needs. The next step is the process. So we receive the data. Now, what do we do with it? So Data Hub, as I mentioned, is our internal platform that supports operational and research needs. And because we have a lot of information and we have various sources, we need to make decisions. So, like, for example, who do we need to notify, which contact information to use, whether their address or phone number is valid, do we have a valid zip code, etc. So we have logic implemented to select the most accurate, up-to-date information. And after that, all the records once we make those decisions, all the records flow into what we call Microsoft Dynamics, MSD. This is a platform for within the Microsoft ecosystem. So with Microsoft Dynamics, this is our case management system. So with this, we can manage cases, manage communications, track engagement outcomes, generate reports. We also can implement call script for the staff who are making live calls as well. So once we do that process and we know what information we're going to use, what happens next is the output, which is basically what goes out, the notification that people receive. And Basically, most of our notification happens with Microsoft Dynamics. Microsoft Dynamics manages all communications, and we use the platform Twilio. Twilio is a cloud communication platform, and this allows us to make calls, to send text messages, and track the status of those communications as well, especially the automated ones. We have 4 communication methods. One is phone call, text messages, emails, and letters. And we have 2 delivery types, which is manual and automated. The system identify, the way that is structured is that Microsoft Dynamics identify what population should get a live call, what population is going to get a robocall. So for example, a live call is made 7 days before the court date and on the day of. So the system is already designed to show us every record that we need to contact 7 days before the court date. For robocalls, there is a web job already scheduled. So every morning at 6 a.m., this web job is activated and all the robocalls go out. That is 3 days before the court date and the same day of the court date as well. And we also send automated text messages and emails. One of the things that we do with all of our communication is that we have all of our contact information implemented there in the communication. So people can give us a call if they have any question about notices. And we also have a helpline that we have a staff basically fielding all these incoming inquiries. So basically, not everybody gets every type of communication, but for the most part, they can receive multiple communication. And we can also generate reports from there. So just to put this into perspective, I just want to share some numbers that I have here. So in 2024, CJ sent more than 869,000 court date reminders, with 40% being phone calls, 30% text message, and 27% letters, and 3% emails. Okay, that's all for me.
Okay, thank you. And now we're going to turn it over to Eric Jackson, who got Buncombe County up and going basically on his own with code for Asheville. Eric?
Hey, everybody. Thank you. I want New York system, actually. But so this started back in 2018. We had a grant-funded process to try and reduce the numbers of people who were in jail, and quickly determined that failure to appear, people getting arrested for not showing up for court, was one of the main drivers of the jail population. And so it was pretty obvious to everybody involved that we needed to push court reminders. The problem was that the state had a system they provided that was so difficult to use that even with lots of pushing, over several years, they only managed to sign up dozens of people. And worse, the state would not allow Buncombe County to build their own system. So a group of volunteers, me and a couple of other people, just went around. We built our own simple system. We scraped the state website in order to get the court dates. And our goal was to make it really, really easy to use. There were some other features I won't go into, but really just the main goal was to make it easy for people to sign up. And it was kind of organic promotion. And when I say easy, I mean, this is essentially all that's involved. You type in enough of a name to narrow your search, pick one of the ones there on the right that has your court dates, go ahead. Put in your phone number, click sign up, and you're done. And we've got it configured so that it sends a couple of messages, one a week in advance with some warnings about consequences, and then one a couple days in advance encouraging people to make arrangements for transportation and so on. So, as I said, kind of organic. We had signs up in the courtroom and people, encouraged people to sign up, and we went from dozens to hundreds, which is better, but not great. This is an opt-in system, and as Shannon said, you really want to automatically sign people up. We were not able to do that. But we worked out with the jail so that it would be offered at people being booked in. We have about 50% opt-in rate there. As well, take it back a second, as well as the ability, as well as some additional advertising, and we took it up an order of magnitude and have maintained it there. year ago last summer, the state has been moving over to a new CMS. And when Buncombe County got moved, we were going to lose access to the website we were scraping, but we took that advantage of that opportunity to leverage our success. And we now have a sanctioned data feed and are actually allowed to do what we're doing. Go ahead. And we've done some study of impact, and I won't read all those numbers, but basically, whether it's for 6-month failure to appear or 12-month, we're seeing a 27 or 28% decrease in the number of people who fail to appear based on whether they got those messages. As far as the benefits of kind of a do-it-yourself approach, you have full control over the messaging, the design, which was great. The challenge, of course, is that you have a system to maintain going forward, which is trickier for us since we're outside the system, although we're no longer volunteer. And of course, we would love to have an opt-out system rather than the current opt-in. And I'll leave it there.
Thank you, Eric. Appreciate it. No, it is amazing what you've done in Buncombe County, and we're hoping to expand that across more places in North Carolina. So let's talk about sort of like the nuts and bolts. How do you do a reminder system right? So essential components, plain language, don't use anything overly technical. Say warrant, don't say KPS or summons. This is more for written reminders and letters. Use clear descriptive titles. Put all the important stuff at the top. Do not bury the lead at the bottom. And courts love using all caps all the time. Don't use those because everything capitalized means nothing's capitalized, but you can use it in the titles. Content, behaviorally, make the consequence of not appearing really obvious. If it's a fine or a warrant, say it and say it loud right next to the court date. Leverage plan making, which I'll show you how we do that in a message. Offer help, give people a number to call, refer them to your website if it's helpful. And use their name for relevance. People who say, oh, it says, oh, Shannon, I'll keep reading. And then offer instructions. So the most important thing is if somebody misses a court date, tell them what they can do to cure that before a warrant issues. And our strongest suggestion, you have to tell people you're not going to arrest them when they come to do that. Same for a warrant. If they have an FTA warrant and they want to cure it and clear it, tell them that when they come in to do that, they're not going to be arrested for that FTA warrant. This is the population the farthest away from the court and the ones you want the closest and to come in. So you're going to have to change your process to get them in there, clear that case, and get them off your docket. These are examples. Sending 3 reminders, 7, 3, and 1 day before. As you can see, the 7-day says consequences, show up to avoid an arrest warrant. The 3-day, again, says what time should you leave, other arrangements, write out your plan. Evidence shows, research shows that if you take the first step in a plan, you're more likely to continue on in that plan. So prompt that. And then 1 day before, again, things come up, people might forget. Explain to them, again, missing court can result in an arrest. And if you can say anything that brings down the fear, like a public defender will be there, or most cases end in fines and you have 30 days to pay, say it. It'll help people get to court. Most important and often ignored are texting people after they've missed a hearing to say, hey, you missed court, and then give them instructions on what they do. And again, you can say it's a one-time courtesy, but again, telling them to do this before there's an arrest warrant. And then after a warrant issues for FTA, tell people you have a warrant. This is how you clear it. You won't be arrested when you clear it. Timing, text, you can send 3 texts, 7, 3 in 1 day. Email, 3 emails, 14 days, because it might take longer for somebody to open their email. Mail, 1 mailed item because mail is expensive, but again, still works. And phone calls, again, heavier lift. It takes about 3 chances to actually get somebody on a call. So it is really highly contextual. There's no one size fits all. You all have different processes and capacities. We can help you find what works for you. But the golden rule, auto-enroll whenever you can. Send a reminder before all hearings. Use behavioral content and timing because you want it to be optimal. Now, I'm going to hand it over to Chris at Scottsdale Municipal Court, who we've worked with on their notices and their text messages. Chris?
Thank you, Shannon, and great to be here. Here in Scottsdale, we've been working with Ideas 42 on improving court notices and updating our text messaging platform. We've had text messaging for several years, but we're really looking to update it. And we're doing that by incorporating behavioral science to more effectively communicate with our litigants. Some of the main goals of the Arizona judiciary, similar to some of the other jurisdictions, is to promote fairness and access to justice. Kind of our North Star is effectively using the Ideas 42 method to improve our communication. And really the goal is to increase our appearance rate for litigants. Some of the challenges that you may face, depending on the jurisdiction, without the litigant phone numbers, we mentioned it previously, if without those litigant phone numbers, you're not going to be able to leverage text messaging communication. So that's something you're going to have to work with your law enforcement or your Supreme Court to try to make sure that you have the ability to collect those phone numbers to leverage the effectiveness of text messaging. Here in Arizona, we're lucky that all of our phone numbers, cell phone numbers, are captured on our statewide citation, so we're pretty grateful for that. We are including all relevant information on best ways to communicate with our court, and this includes the consequences of inaction. We on our redesign for all of our reminders, it has been extra work on our leadership team and our IT team, but we can see how much we've improved our reminders, and there's so much more easily to follow, and clearly gives litigants all the information that they need to better address their legal matter. On this slide, if you look at the lighter blue-green is our current text messaging platform, and the darker blue is the improved Ideas 42 text messaging. For upcoming court dates, we include the walk-in time, the consequences of inaction, and that would be for and the top row is it would be for an arrest warrant for criminal cases. In traffic cases, it could be the potential to block their driver's license. We've also added the website link to the court. What I love about that is that we're adding the website link. It's more text user-friendly for the user on their phone. And we also added our main court line for phone numbers for questions. As far as the bottom text messages series on the bottom, these are reminder text messages for when the litigant actually missed the court date. We give them information about the rescheduled court date and the due date. And again, we've added the court number for questions. And we include this in the text as a one-time courtesy for them to act now to avoid a warrant. For our communication with litigants, words matter, and so does the cadence of when we send the text messages, as Shannon mentioned. And what we were looking for the communication that's the most effective. So making text messages easy to understand and giving the right information saves our jurisdiction time and money, and hopefully avoiding the endless trappings that we see with people always perpetually in warrant status. And this is, for us in Scottsdale, this is fair justice in action. I'll turn it over to Shannon.
Thank you, Chris. And it's also to say that, like, so we had a lot of discussions with the court. Like, can you say, you know, that you're going to avoid an arrest warrant? How do you distinguish between civil and criminal? So again, it takes some thought beforehand, but we've been really proud of the work we've done with Scottsdale and what their final product is. Oh,
Thank you so much, Shannon. And I am excited to bring our discussion into a discussion around why it matters, talking about how reminders work, what they look like, the behavioral science behind them, what is the overall importance of this. And so, because this ultimately is not just about getting people to show up for court, it's about what showing up represents for the individual and for the system. It's about fairness, efficiency, and ultimately trust. So let's take a quick step back and recap what we've seen. The challenge is pretty big. About 1 in 3 court dates are missed nationwide. That's a lot of hearings that have to be rescheduled, and behind each one is a person whose life just got more complicated. The impact of that is real. Missed appearances can lead to warrants, jail time, lost wages, or even loss of housing or benefits. And on the court side, it means more administrative work, higher costs, and less trust in the system overall. But there's also an opportunity here. Most people actually want to make their court dates. When we give them clear, supportive reminders, they show up. So this isn't an unsolvable problem. It's something we can absolutely fix with the right tools and the right approach. So why does all of this matter? Beyond just getting people into the courtroom, reminders help reduce system waste. When people make their hearings, courts don't have to issue as many warrants or spend time rescheduling. Every reminder saves time and money that can be used for other priorities. Second, they increase fairness. Missed court dates often hit low-income people the hardest, folks who might not have childcare, transportation, or a flexible work schedule. Reminders help people stay on track instead of getting penalized for challenges that are often beyond their control. And finally, reminders help build public trust. When the system focuses on helping people rather than punishing them, it sends a powerful message. It shows the court is on their side. The same way other systems in life remind us about appointments, whether that's a doctor's visit or your kid's parent-teacher meeting, it's important to recognize that these appointments are ultimately building public trust. Together, these changes add up to something bigger, a justice system that's fairer, more efficient, and more human. So with that, I'll hand it back over to Shannon.
Thank you, Bridget. So we just wanted to say, like, one more time, how much a missed court date costs, both the system and people. But sometimes you might need to go to your administrators and have, numbers that apply to your jurisdiction. So you can reach out to us and we can help you do this. But let's say that annually your jurisdiction or county has 25,000 missed court dates. So that's a cost only to the government, not to the person, of about $37.5 million. Now, with reminders should reduce your non-appearance rate by 26%. That means you'd have 6,500 more hearings attended. And that would save annually $9.75 million, again, for a very low cost, but really high benefit. So again, reach out to us and we're happy to run some of these numbers for you and present to anybody that you would like. So we have a resource. We just published the Essential Guide to Court Reminder Programs. It has all this information plus much more in it. So we'll be sending out a link to that after the webinar, but you can also call us. So my email is here. We're also at unwarranted@ideas42.org. And again, we can help you through this. We can give you examples of reminders, do the calculation, show you fact sheets, and any other technical information that you need, and also help you troubleshoot some of those more complicated processes. So anyway, thank you so much for being here. And I think we're going to launch into our panel discussion now.
Great. Thank you so much, Shannon. All right. Now that we've heard from each of our practitioners about their work, we're going to bring everyone back together for a discussion about how these pieces fit together. This part of the session is really about connecting the dots, looking at how research, behavioral insights, and on-the-ground experience all come together to make reminder programs work. We'll also talk about what any jurisdiction can start doing right now, whether you're building a reminder program from scratch or strengthening one that you already have. So before we get started, I'd like to invite the host to take the slides down, which I believe has already happened, and to spotlight each of our panelists who have presented on what they are doing on the ground, so folks can easily see who's speaking as we go along. And as we get into the discussion, we'd love to hear from all of you in the audience. If you have questions for any of our panelists, please go ahead and drop them into the Q&A box at any time. We'll be keeping an eye on those throughout. All right, so let's go ahead and get started. So we did have several questions that have already come into the chat. So I'm going to go ahead and start with the questions that have already come in. So we had one person say, "Thank you so much for presenting. I have so many questions, but do you have an MOU or legal arrangement with the Office of Court Administration to get their data? Can you share more about your logic for how you approach the MOU process and the legal arrangement?" So, if anyone would like to discuss how that process works for them, please feel free.
Yeah, I think that's directed towards me about the OCA data. So DCJ, oh, let me put my camera on. All right. So the Data Collaborative for Justice, we have a pretty good relationship with the Office of Court Administration. So we have a data sharing agreement that usually advances several years into the future. So we're in a very privileged position to have a non-public OCA data set that has more detailed data than what you generally find in the public OCA data sets.
Eric, it might be great for you to talk too about.
Yeah, I was going to jump in because I'm sort of way on the other end, or at least we were originally, where we did not have permission. And in fact, we were nervous for a couple of years that they might take away our access because we were just scraping the public website. The advantage of doing that is that we were able to prove the value without having to go through jump through all of the hoops. So that when it came time, when we were about to lose access to that because of the new system, we were able to basically say, look, we've got everybody locally bought in. We had a huge amount of support from the county and the public defender's office and judges and so on. So we were able to say, this is working. Why would you destroy it? And at that point, they set up an official feed to the county, and the county gave me access to that. So you can kind of come at it both directions. It's great if you can just get a sanctioned data feed, but you can also sort of go around if there is a publicly accessible interface to the information you need. And then we have the sign up side, which we did independently.
Thank you, Eric. And this person also had a follow-up question around things like how do you validate phone numbers? For example, using Twilio's lookup API, is your Twilio integration a managed service or a more do-it-yourself model? So this person is wondering if any of you all would like to share more about your process of validating phone numbers, as well as your process for collecting and storing consent for SMS messages.
I can speak a little bit.
Go ahead.
So I can speak a little bit about that. So in our side, we do have a legal agreement with the Office of Court Administration to receive the data. And when it comes to validating phone numbers, what we did is we implemented, and I believe it is Twilio lookup, what it's called. And what we do here is that with this feature, we enter a phone number and we are able to validate if it is an actual cell phone number that we can send a text message to. So we utilize that feature. And in terms of getting the consent, one of the unique things about CJ again is that we conduct our own release assessment. So during this conversation, we actually obtain consent to send notification to clients, text messages, etc.
Great. Thank you so much, Jeffrey. This next question I'm going to direct to Martha, but want to just kind of peg that any of the practitioners please weigh in if you have additional thoughts to share. This question comes from the audience, wondering how you were able to get buy-in from the both political and the operational side and funding for this work. Just thinking about cross-agency collaboration and getting the buy-in that was needed. Whose buy-in was most important or most challenging to get, and why? So we'll start with Martha and then welcome the other panelists to weigh in.
Yeah, well, in terms of redesigning a citation form that's used upwards of 3 million times in a year by 500 different law enforcement agencies, buy-in was obviously crucial, and it was something we were concerned about from the beginning. But I really think, and the slides here reinforce that point, just about everybody agrees FTAs are a problem. They're a problem for everybody. And it's something that everybody from their own perspective wants to do something about. I think the most important buy-in to get for us, at least for the citation form, was law enforcement. And there are a lot of different ways you can do it. Some easy ways at the very beginning with just looping in your counterparts and agreeing on your overall objectives. And then more challenging ways that we're still working on even now, a couple years later, which is all the way down to local law enforcement level, really helping to support their use of the citation or of a new tool or a new practice, whatever it might be, out in the field. It can be challenging, but it's really worth it to try and find the right channels one way or another.
And if I can also say that it can be a long process, and that's okay. So we were working with Martha on something else in California, and she said, like, can we present to your like traffic advisory council like years before? And kind of nobody really was interested in all of that. But then we like slowly built the interest and then said, listen, something came up and they had to change their citation anyway. They had to add something to it. And we said, Martha called us and said, this is the perfect chance we can now add the phone number field. So again, it's a long and winding road, but I think we're all here for it. Change takes some time.
Chris, Eric, or Jeffrey, do you have anything to add to that?
For us in Arizona, we got in on the pretty ground floor of it in 2014. So it was kind of an easy sell because we mentioned dentist offices and those that were working with that. And we were able to, look at some of the data they showed as far as their appearance rates. And we were able to pilot with the Supreme Court and got the go ahead. And Martha mentioned the challenge of getting the citation changed. We got that done pretty early. So we hit the ground level. So it was a little bit easier for us, but just being able to, Shannon talked about the cost benefits and being able to have data analytics that can point to that. I think that can really be leveraged from a political standpoint to push for the improvement of having reminders in your organization and your jurisdiction.
All right, thank you very much. Now, this question is around clients who are unhoused. Any tips for unhoused clients who only have phone numbers that require internet access and as a result of that are unable to leave a message? In this person's jurisdiction, they say that these are the defendants who have the highest or most frequent FDA rates. And so thoughts on that situation, how you would approach that?
I can jump in on that. And a lot of this we haven't implemented yet, but would love to. So one is allowing anybody can sign up on somebody else's behalf. And so one of the things we have some of the case managers at the day center who will sign up and then remind somebody. A family member can do it and so on. The other, and I know Twilio, for example, has the ability to add to message through WhatsApp, just as part of their regular service. And I have explored using Facebook. The other thing I've thought about is kind of grouping together, having a day center or a shelter sign up their own people and get an email with everybody's court dates for the coming week. So there are some strategies you can use, and that's where having a custom system gives you some flexibility that maybe another doesn't. So, but that is something we've thought about and haven't fully baked in how we're going to approach it, but there are a number of things that you can do to begin to address that problem.
Martha, Chris, or Jeffrey, any additional thoughts on reaching folks who are unhoused and are therefore unable often to receive messages?
Yes, I can add that, that's one of the things that we're always thinking about. How can we support this population? And some of the things that we do is always, like, for example, when we initially conduct our release assessment, we try to do another interaction with the client and try and see if there are additional contacts, or for example, if they don't have a place where they live or anything like that, do you have any friend? Do you have someone that we can contact, that we can send a notification to? Also, one of the things that we have here in the outreach department at CJA is that we operate a helpline. So sometimes we get like family member contacting us on behalf of their family. So we try and see like how are there any updated contact information that we can utilize? But we continuously thinking about options, ways that we can like tackle that area. But sometimes it's a challenge, or a lot of times it's a challenge to do that. But we're always thinking about what else can we do in addition to the initial release assessment. What else can we do?
Okay. Thank you very much. So this next question is someone who has a volunteer pretrial services pilot project in their county. Their goal is to have this type of service provided by the county-supported nonprofit. And they're wondering whether any of the panelists have suggestions for strategies to attain their goal of having the county-supported nonprofit provide this service in the county. So any thoughts on how this could potentially look and play out?
It's a little bit like our model. And it really depends on what the capacity of the nonprofit is. So if they have the ability to bring in custom developers, it is a pretty simple system. It's not a complicated. And if they're being county supported, I assume that means that they can get a data feed and so on. So it's pretty doable. The other thing is they could contract to use one of the commercial products, but be the primary relationship with that vendor. So those are my two thoughts.
We mentioned that the importance of sometimes the MOU and or intergovernmental agreement, some of those type of those, making sure that gets vetted.
Okay, great. Now, this person is asking, was there user research or user testing to inform the design of these messages and delivery methods, or was the design more based on already known best practices?
So that might be for me since we're designing the messages. Yes, they are. So we did a rigorous study that had 4 different groups. So no message, one message that just said, this is your court date, another message that said, show up to avoid a warrant, so the consequences, and then the third about plan making, what time do you need to leave? And by far, the most effective proven is mixing consequences and plan making. So yes, it was a rigorous study out of New York City, and there are many more. There are meta studies. If anybody is interested, you can email me and I can send you all of the studies. But by far, the behavioral content is the most effective. If you're trying something new, though, we also think that you should user test. So for example, when we redesigned the California citation, I flew out to California. We did user testing with clerks, with law enforcement, with people who receive tickets. So again, you want to test anything that you are giving to your litigants because you have the curse of knowledge and you don't know what people are going to understand or not. But again, there are lots of studies and I can direct people to those.
Great, thank you very much. So this question is coming from Hawaii, and they're asking about their judiciary-run e-reminder system for court appearances. Hawaii says it's a good start, but reminders alone could do much more if coordinated with supervision and surety functions. How can we expand or improve this tool to reduce failures to appear and support defendants while keeping accountability and judicial discretion intact? So what I'm hearing is they're wanting to know how to improve their existing tool and expand on it while maintaining accountability and judicial discretion. So I'll open that up to the panel for anyone who would like to weigh in on that question.
I mean, I do know something about Hawaii, and that is that you require people to sign up. So there's going to be a low usage. I don't believe on your citation you have a phone number field, or if you do, officers aren't collecting it. So again, we're trying to work with Hawaii and would love to say, how do we improve the system? So there are a fair amount of states that have an e-reminder system. It's just not highly utilized. But so those are sort of some of the issues, like auto enrollment, thinking through contact information, and having really good sources. The accountability part and the bonding, I guess that would be a moment when you could collect a phone number. But yeah, that's sort of what I know about Hawaii. And it is a really great start.
Yeah, and I was just going to say that I can put a link to the information we have on our website about California's pretrial release program, but I think you're trying to get at some of sort of all of the menu of complementary services for people in that pretrial phase when they're released, hopefully at an amount of bail that they're able to pay, if they're safe for release, and then getting ready and waiting for the right information for when to show back up. So we have a link of some reports that we've done and studies and sort of the way probation works with the judiciary to even in this pretrial phase or this pre-hearing phase to get people complementary supports to get them to show back up.
This is kind of a broader question that I'd like to ask you all. What's one thing that you wish you'd known before launching your reminder program? Like one thing that you didn't know starting out, and now looking back, you wish that you had this information going into implementation.
I could answer that from Scottsdale's perspective. I mentioned that we launched this in 2014, and not knowing some of the behavior science. Courts are notorious for acronyms and kind of legalese. Some of the behavioral changes that we've made, and also the cadence of how many times we're sending that out, and having that data driven. I think for many years our program could have been even more successful, but we're making those changes now, so we're excited about that.
Eric, Jeffrey, or Martha, do you have any additional thoughts on one thing you wish you had known?
I do. I don't know that it would have helped as much as I would like, but it would have been nice to have had more of the research that said that opt-out systems, automatic enrollment were legal and were proven much more effective, because I think that's the biggest weakness in our system, even with good community partners and partners within the court system. There's just a limit to how many. I mean, our big sign up is because it's offered by the jail. We could do so much better.
What is, and this will be the last question before we close out. What is the most surprising part of this whole thing for all of you? What's one thing you thought that was going to be easy that turned out to be hard, or vice versa, something that was hard that turned out to be easy? Was there anything that was surprising to you in the implementation of this?
Yes, from Scottsdale, all of us are very seasoned court professionals here. Many of us have 25, 35 years in judiciary, kind of unlearning what we know about courts and trying to get it to be, user-friendly and think like a defendant, put it in their eyes. I think that was a little difficult for our team, but, Shannon and Ann have been more than patient with us on that. So that's been very, very helpful. But that at first it was hard to think like a litigant as opposed to someone who's been in judiciary for 34 years.
Thank you. And Jeffrey, I saw you go off mute, so I'll let you answer as well.
Sure. So what I can talk about is basically when we started when we switched to the system that we're utilizing now, one of the things that I can think about is the automated notification that goes out, the robocalls, making sure that people do not perceive these incoming calls as scam. So that was one of the biggest thing, and we worked through different ways that, how can we support this? And it was basically finding believe like the phone number, making sure that it comes up as and doesn't come up as a spam likely. That was one of the things that happened initially, or one of the challenges, and making sure that the callback number, the contact information for our department is visible, is available to all clients receiving all this communication, so they can give us a call to get any answer in terms of the notices that they are receiving. So initially it was a little bit of a challenge, but now I think everything is just going out smoothly.
All right. Well, thank you, everyone, Martha, Jeffrey, Chris, and Eric, as well as the whole team at Ideas 42, and Renee for sharing your insights and experiences and for all the work you're doing to make the justice system more fair and effective. A big thank you as well to everyone in the audience for spending time with us today. We know how busy your schedules are, and it means a lot that you joined us for this conversation. Keep a lookout for a follow-up email in the next week or so with resources, as well as a link to the webinar recording and slides. And on behalf of Ideas 42 and the Data Collaborative for Justice, thank you again for being here and for all the work you do every day to advance fairness and access to justice in your communities. Have a great rest of your day.
Thank you, everyone.